Hi there, I'm Matthew Cannings. I'm one of the barristers at 3PB and I'm head of our Property and Estates Group. Just bringing you a quick case update and an important landlord and tenant decision that was handed down by the Court of Appeal yesterday, the 18th of June 2020. The case is called Trecarrell House Ltd and Rouncefield, and it relates to gas safety certificates and their interaction with Section 21 of the Housing Act 1988. Some of you might be familiar with the case of Carradon Property and Schultz. It was a 2018 decision of His Honour Judge Luber QC sitting in the County Court in London. Whilst not binding, that decision turned out to be highly persuasive authority and, as I understand it, was relied upon by district judges and deputy district judges regularly in the County Court. What that decision said was that if a landlord failed to serve a copy of the last made gas safety certificate prior to a tenant entering into occupation of the relevant property, the landlord could never rectify that error and could therefore never rely on the Section 21 no-fault eviction procedure prescribed by the Housing Act 1988. Well, yesterday the Court of Appeal effectively overturned that decision, and they've ruled that as long as a landlord has served a copy of the relevant gas safety certificate prior to serving any Section 21 notice, then this complies with Section 21A of the Housing Act 1988 and means that a landlord can rely on the Section 21 notice eviction procedure. This brings the provisions, or in fact confirms that the provisions are, in line with the provisions relating to things such as how to rent booklets, energy performance certificates, and the protection of tenancy deposits and the provision of prescribed information relating to the same. Some of you will be familiar with those provisions and the issues that have arisen in the past there. And what Trecarrell House Ltd now confirms is that the provisions are essentially the same in relation to gas safety certificates. So, as with energy performance certificates, how to rent booklets and the protection of deposits and the prescribed information relating to the same, if a landlord makes any error in relation to gas safety certificates, as long as the landlord has served a copy of the relevant gas safety certificate on a tenant before they serve a Section 21 notice, then they can rely upon the Section 21 notice eviction procedure. I've written a small article on the case. You'll find a link to that next to the link to this video. And in that article, there's also a link to the judgment in Trecarrell House Ltd, which is available on Bailey. No doubt the case will be reported as well in due course. Thank you very much.